All right, hi again. Welcome back. Attorney Steve Vondran, and welcome to another exciting video. Okay, so I had a question. Somebody said, I'm hearing this word hearsay all the time. Hearsay, all these things about hearsay. I know what it is. It's somebody else saying something. It's kind of through the grapevine kind of thing. But what is it really in legal terms? Without further ado, let's head to the Attorney Steve Litigation Whiteboard. Okay, so here we have it. I have it up here on my handy screen here. We have the declarant, we have the witness in court, okay? This is what we're talking about. I tried to draw a picture of a court here, and here's the person who's not in court. What we say, he's out of court or she's out of court, okay? Now, hearsay is an objection, okay? Basically, it's an objection. So not so much in like depositions or anything. You can point it out in a deposition, but definitely at trial where you want to say, Judge, I object. That question calls for hearsay. It calls for hearsay. Now the judge has to make a decision. Does it call for hearsay? Yes. If yes, are there any exceptions where it might come in? And there are a lot of exceptions, maybe 20. Sometimes they say the exceptions swallow the rule, okay? But let's talk about it. So it's an objection. If the court sustains the objection, then the evidence does not come in. Okay, so that's really all we're talking about. I'm going to try to make this video quick, though. I'm not going to go over all the exceptions, but here it is. Let's take an example. Here's your out-of-court declarant. Now, maybe they're in another country. Maybe they're on their deathbed and they're unable to testify, okay? But this person in court, let's call him Billy. Billy's called to testify in court, and they ask Billy, well, what happened? Do you know who did the murder? And Billy says, well, I heard Mike say that Joe is dead. Sue killed him. And you say, wait a second. The person here the prosecutor, for example, or the defense attorney may say, I object, Your Honor, that calls for hearsay. Well, what do you mean? Well, Billy is trying to testify that Joe is dead. Sue killed him because that's what Mike said. Mike said it. But Mike's not here. Mike's out of court. Mike cannot be cross-examined. So it's very hard to tell if this is a truthful statement or not. And that's the problem with hearsay. We don't want to let unreliable information get to the ears of the jury. Can you see my jury here? This is a top bird's eye view for you. You could tell I had some extensive art classes, can't you? So the hearsay is to allow the jury to assess the credibility of the statement. Now, if you want the Hornbook rule for you're taking the bar exam, you say, well, what's the rule? Hearsay is an out-of-court statement offered for the truth of the matter asserted. So if you're offering this evidence to prove Sue is the killer, that may very well not come in as evidence, okay? Objection, hearsay. Maybe it's the defense attorney says, I'm trying to protect Sue. Objection, hearsay. The judge has to decide. Is this hearsay? Inadmissible. Sue goes free. Is it a hearsay subject to an exception? Hey, if we can find an exception, hearsay comes in. It's admissible. So hearsay can be admissible. Okay. Now, I'm just going to give you 3 of my favorites from law school. The list is about 20. There's a catch-all, which says, well, if something's reliable, we'll let it in if it makes good hardcore sense. But here's my 3 favorite from law school. I'm not going to give you the whole list here because I want to keep this short. The dying declaration. Now, if Mike's over here and he's on his deathbed and somebody asks him for a confession, or one of his brothers or sisters says, do you know who did the murder? And he says, Sue did. Sue killed him. Sue killed Joe. That is a dying declaration. And the courts would consider that, well, maybe he's being more truthful because he's on his deathbed. That is a dying declaration. So when you get objection hearsay, counsel, what do you have to say? Your Honor, this may be hearsay, but it's subject to the dying declaration rule, and it should therefore be admissible. Judge's got to make a ruling. Okay, judge has got to make a ruling. Obviously, this is critical evidence. The jury is going to either hear this or they're not going to hear this. And these can be the basis for appeals if the judge makes the wrong decision. Okay, especially if it's prejudicial. Now, here's another one. Admission against interest. So if Mike's over here and he's going, well, Joe is dead. Let's change that to I killed him. I killed him. He's at a bar or in jail and he says, Joe's dead. I killed him. Well, that's a statement against his interest. It's a declaration against his own interest. So that may come in as evidence, okay? And the final one I'm going to give you is excited utterance. I love these, and these should be on the bar exam because they're a little bit easier than the other ones. But there's a whole big long list if you really want to get into it. I'm not going to do it here. Excited utterance. So if you're watching something, like for example, you see somebody run up and pull out a gun and aim it at Sue. You go, oh my God, I saw him. He's pointing a gun, 911. He's pointing a gun at Sue. That is an excited utterance. An excited utterance. That can come in, okay? So the whole point of these exceptions is that the courts, over time, over case law, have decided that these are relevant, that they're probably more, they're probably more strong evidence than weak evidence. They're probably more reliable is what the word I'm looking for. They're probably more reliable than unreliable. So there it is. So that's hearsay. So when you hear somebody talking about hearsay, it's an out-of-court thing. This is from the legal standpoint. And it's somebody who's not going to be here at trial, so we cannot cross-examine them. We cannot cross-examine them. So usually that means we don't know if Mike's telling the truth or not. We don't know. Because it's out of court, he's not being subject to cross-examination from both sides, prosecutor, defendant, defense attorney, plaintiff attorney, whatever the case is. That's hearsay. So when you hear that next time, you're going to go, I know Attorney Steve told me about this. Hearsay, it's an evidentiary question. There's a bunch of exceptions, and it's basically when you can't cross-examine someone. That way we don't know if it's real or not. We don't know if it's true or not, okay? So there it is, folks. Out-of-court statement offered for the truth of the matter asserted. Now, there's other occasions when you're offering it, not for the truth of the matter asserted, but for other things, and I'm not going to go into that, okay? So, but that's what it is. I hope that helps. That's my tip of the day. General legal information only and not legal advice. Attorney Steve, have a great weekend. Thank you all for watching. Make sure to subscribe. You got to be getting tired of politics by now. Everybody is. Everybody's getting grouchy. Bookmark my page, subscribe, join 16,000 others who enjoy learning something instead of just getting all bundled up and mad about something, okay? Have a great weekend. I got to go. Go Fresno State Bulldogs tonight. Let's win in San Diego. Take care. Bye now.